Okay, Tolis, really glad to have you.
Thank you.
Let's start with some kind of information about you and your law firm. So if you can just give me some background, where you started, how you started.
So I have been a startup lawyer focusing on technology startups and entrepreneurs here in Seattle for approximately two and a half years now. Prior to that, I was a general counsel for an investment management firm here in town where I focused primarily on securities regulation and compliance, as well as intellectual property law. And prior to that, I have sort of a mixed history. I've been a consultant at a Big Four consulting firm in Washington, D.C. And prior to that, I was in the U.S. Navy, where I litigated cases for 4.5 years. And during which time I got an MBA with a focus in finance out of George Washington University. So my undergrad is in aerospace engineering. I've got the MBA and I've got the law degree. So when I started this practice's firm several years ago, the intention was to find a way to marry all those backgrounds into one job, one opportunity.
That's very nice.
And so I felt this was the best place, especially with a technical background, because I kind of understand where entrepreneurs are and what they're doing. Consequentially, I've also been a software product manager for a startup in Bellevue. So that's how initially I relocated to the Seattle area. So I've done that as well. So I'm very familiar with the software development life cycle. So I know exactly what software startups, internet startups are doing.
And you specialize with what areas of law, like what areas you consult in?
So technology, so the types of clients are technology clients, clean tech clients, biotech clients. Within technology itself, I have all sorts of clients. So I have analytics companies, gaming companies, software as a service companies, enterprise software companies, media companies, you name it. So I have a variety of technology clients. In terms of the services I provide, my focus and concentration is on corporate governance. So forming and establishing companies, figuring out the equity splits, that sort of thing, and then securities regulation aspects. So how to bring money into the company in a safe way, so as not to get in trouble with the Division of Financial Institutions or the SEC. And then a third area that I work on quite substantially is contracts. So if you're going to contract with your customers, with partners, that sort of thing, I do lots and lots of contracts. And finally, a smaller part of my practice is employment law. So as my clients scale out and grow, helping them to scale and bring on employees and that sort of thing.
Okay.
By the federal laws.
Very nice. So let's move to our first topic, which is how to form the company.
Right.
First, if we can talk about what kind of legal entities are existing and what is the difference between those.
So basically, there are three options. So the three options are a corporation, an LLC, or a partnership. Let's get rid of the partnership right off the bat. Partnerships are typically law firms or accounting firms, that sort of thing. And partnerships aren't necessarily a type of entity that you need to register. It's sort of a common law, like you and I can be partners. So people use the term partnership oftentimes wrongly. So you have to be careful how you say partners, especially prior to forming a company. So, which is an important part. So before you form a company, you are, in theory, in business with a co-founder if you're working together. If you do not form a company at some point, then you may be imputed to be a partnership. So if you and I have a deal where we say, look, we're going to be 50-50 partners in this, guess what? We are. We just did it. You don't have to do anything else. So partnerships are not a great, obvious structure for technology startups especially. They don't make a lot of sense. And they're a good reason, partnership laws, especially in the state of Washington, they're a good reason to actually form an entity. So that leads us to the LLC and the corporation. So LLCs, limited liability companies, very flexible. So flexible, in fact, in the state of Washington, that you have to do more than just go with the default rules that exist in state law. You have to actually make some choices around them. So that flexibility is wonderful, but it also requires you to put in place something like an LLC operating agreement. And LLC operating agreements are basically the understanding between the owners. How are we going to apportion ownership amongst us? What happens if one of us leaves or is unable to continue? That sort of thing. Because state law doesn't make provision for it. So you have to put something in place. LLC operating agreements tend to be on the long side. very difficult conversations to kind of get through preliminarily as you're doing your startup, and oftentimes founders are moving 100 miles an hour. They don't want to focus on that stuff. As a result, you may put an LLC operating agreement in place, you put it on the shelf, and you never refer to it again until there's a problem. At that point, you don't really understand what it says. You have to go back to your lawyer. So they're not a particularly great way to work. Nobody has a very firm understanding of how things operate. The other part of LLCs, which is actually probably most important, is how you contribute assets, services, cash to establish the LLC. So the default ownership structure in an LLC is contribution. The contribution comes in the form of cash, assets, or services. Unless you put an LLC operating agreement in place that says our default ownership structure is going to be units or shares or whatever it is you want to call it, your ownership percentage is based on your contribution. So you have to, in a spreadsheet or some way, financially track what the various owners are contributing, and their ownership interest is based on what they've contributed. So that may change over time, which is not good either.
Don't you need to do the same also for other structures, or?
No. So in a corporation, so that's a great segue into corporation. So a corporation, when you establish it through articles of incorporation or certificate of incorporation in Delaware, which we'll talk about in a little bit, you establish the ownership division up front in the actual articles or certificate of incorporation, in the actual filing document, right? Well, I should go a little bit more into that. So you'll establish how many shares you can authorize, and then you'll actually sell them to the various members or shareholders, and that'll be their ownership. That's it. It's locked until there's another transaction, another sale, or a grant through an option pool or something like that. In an LLC, that's not the case. In an LLC, if I contribute more of my services, it's very possible that my ownership interest will increase, which means somebody else's is decreasing. So that provides uncertainty in the LLC, which you can get rid of through an LLC operating agreement. Well, once again, it's a little bit painful to go through that process. So corporations are a great alternative where you and I, let's say, want to get together and form a company, let's say a technology company, and we know what your contribution is going to be. You're going to contribute your services, and I'm not going to contribute as many hours as you, but I'm going to put in the cash that we're going to need to operate for the first 6 months. So we'll decide what a fair division of ownership is based on our contributions at the outset, and we'll lock it in. We'll say, you're 60 on 40%, and that's that. We're done, and off we go. We don't have to think about it again until maybe a Series A or something like that. So that's what makes corporations a good way to operate.
What is the difference between S-corporation and C-corporation?
So an S-corporation, in many respects, operates like an LLC in that the money that's coming in, the revenue that's coming into the company, passes through the entity and is imputed to the owners. So if you and I are 50-50 owners and we make $10,000 in revenue in our S-corporation, $5,000 of that is imputed to you, and $5,000 is imputed to me in our individual capacities. What that means is I have to declare it on my taxes and pay taxes.
That was my question, so how?
Right. As opposed to a corporation that is a C corporation, which is the default structure. You don't have to do anything to be a C corporation other than file for corporate status. The money stays with the corporation, and the corporation has to pay tax on it, not the individuals.
Is it, so let's say my tax bracket is 30% or 28%. Right. Is it better for me to form a S corporation or to a C corporation? So is the tax bracket for C corporation lower than, let's say, relatively high paid person?
So the impression a lot of people have is that for C corporations, there's just double taxation we always hear about, right? Double tax, double tax. From a personal perspective, it's not going to impact your individual tax bracket. Right? So whatever individual tax bracket you're in, whatever tax bracket the corporation in, those aren't related. The corporation will pay tax at a higher rate, for sure. But a corporation has a lot more expenses. And especially in the beginning where you have nothing but expenses, chances are the corporation itself is not going to be paying tax, but rather incurring losses. The beauty of incurring those losses is that you get to carry them forward for C corporations. So you get to offset perhaps future years of revenue by carrying forward losses from previous years. So the best thing to do is do some planning and figure out, okay, how many years are we going to be in the red? And that's hard to do. And then figure out if an S or a C corporation is the best way to go in conjunction with your personal tax bracket. And I highly suggest involving some sort of financial advisor or planner, you know, that has your best interest in mind with your personal tax situation. So,
yep, makes sense.
Okay.
Actually, the common question is where is to incorporate.
Yeah.
So we hear a lot that okay, Delaware is the best place to incorporate. I would like to know why, and is this still the case? Because we hear also the reverse that said, okay, most of the states now they have similar laws that actually are more pro corporations. So can you tell me a little bit more about that?
So there are a lot of reasons to incorporate in Delaware. First and foremost is the Delaware Division of Corporations. So procedurally, the folks that work there are very, very helpful, and the process by which they actually take in your paperwork that you file and get through it is excellent. One very simple example is faxes. They accept faxes. So if I want to form a new company, I can fax a certificate of incorporation to them without paying any additional fees. Just give them a credit card number as part of the fax, they process it, and you're done. On top of it, I can pay a $50 fee on top of that to expedite that filing. So I fax it this morning, I pay a $50 expedite fee, which guarantees me a 24-hour turnaround, and they will put in the mail my new certificate of incorporation tomorrow. So in 3 days, I could be done, in essence, right? And I can additionally issue them instructions to send it back to me via UPS. So in 3 days, literally, I can have a new company up and running. That might be important where perhaps you have an investor waiting to give you money and you need to form very quickly. In comparison, the state of Washington, in order to fax something in, you have to pay an expedite fee. That expedite fee is $50. It used to be $30, they increased it. And on top of it, it doesn't guarantee you a turnaround time. They say 2 to 3 business days. In reality, it's longer. And it just depends on how long their queue is. So you don't have that sort of guaranteed turnaround that you do with Delaware. So the administrative process is one good reason. The second good reason, and you mentioned other states. Other states are behind, and the reason they're behind is because the state of Delaware has a very well-developed set of laws now, specifically court-made laws. So the state of Delaware has a court of chancery. The court of chancery hears corporate-related matters and shareholder-related matters. And they hear them by judge alone, no juries. Juries make things uncertain. Judges are experts, especially in the Court of Chancery around corporate law. That provides some predictability to corporations who are incorporated in Delaware and have shareholder and corporate-related matters. So, and on top of that, the decisions they issue, the judges issue, are in writing. They're legal opinions. What that permits is lawyers like myself to actually research similar situations perhaps to my own if I'm having a particular issue, right? To see how a judge may rule, which may dissuade a lawsuit in the first place, right? So very well developed set of laws. The Court of Chancery and the judges are experts at what they do and provides predictability, so we have a little more certainty in what's going on there. In contrast, the state of Washington, if you go through Superior Court, people have a right to jury, so that is not great. Right? People don't like that, and the corporate laws are not as well developed. They haven't been in existence as long, and they're not judge-made laws on top of it. So there isn't as much predictability, not as much case law. So that's another excellent reason. So, go ahead.
Are there any tax benefits if you incorporate in Delaware? Or?
No, not really. It is cheaper if we were to compare what it costs to file in the state of Washington. It's $180 plus a $50 expedite fee if you want to do that. So it's $230. State of Delaware, it's $89 plus $9 for every additional page in your certificate of incorporation. It usually winds up being $98 or $107 to set it up. Plus $50 if you want the expedite, you're at $150, let's say.
Cheaper. Yeah, one, because we need to wrap up this segment.
Sure.
one last question. What is your suggestion? Should the founders actually incorporate themselves? Should they file themselves, or do they need actually a lawyer to do it?
I wouldn't say you absolutely need a lawyer. I think it's a good idea to consult with a lawyer so that you can discuss your situation and what you're trying to achieve, so that somebody can help you walk through this decision. Okay, should I be an LLC or a corporation? Here's my situation. Here's the number of founders I have. Here's the space I want to work in. I think it's a good idea to work with a lawyer to do that. That being said, there's a few things following that consultation that you might be able to do yourself after that consultation. So I know I do free office hours twice a month where I talk specifically about these things with individuals that come to see me. I do legal workshops. I have one coming up in October. So there are a lot of different ways to get that advice free and then decide what the best situation for you is. What I will say though is if you're growth oriented and you're looking to obtain capital, it is a good idea to go through a lawyer to make sure your documents are online and that there are no issues that you may not know of, especially if you're going to go through a financing, and lawyers will get involved at that point. You don't want the financing to be delayed because of some technicality around your filing and you have to go back and redo it. So the cost can be minimal. I do a fixed fee to set up companies up front, so it can be very reasonable. You can budget for it, and you can of course find ways to save money as well if you work with a startup.
Can you tell me just approximate cost for filing?
So we talked about the actual administrative fees. So legal fees, my fixed fee package runs between $1,500 and $1,800 depending on what you're trying to do. So and it includes, it's not fair to just throw the price out there. I mean, it includes a variety of documents that go along with it. So you have to do organizational meeting minutes, for instance, that require you to name your directors and your officers and that sort of thing. And that's required by law. That's one of the pieces that people oftentimes forget. And the second piece is they don't authorize themselves or issue themselves stock. So they think they're an owner, but they really aren't until they've sold themselves the shares. So a lawyer will help you with that.
Okay. Thank you for this time.
Yes, it's been my pleasure.